Reprise de débat. The honourable member for Toronto-Danforth.
Thank you very much, Mr. Speaker, and I thank the Minister for his presentation. Along with my colleague from Gander Bonavista, I acknowledge that this may not be the best day for the Minister in terms of his health. And so I may accordingly, and also in the spirit of what we've heard from the Foreign Minister, be a little more gentle than I maybe was intending to be. Everybody who's had time may have had a chance to read the piece that came out today in the National Post, where I make very clear that I do believe, this sounds like how I started the debate on C-23, what we called the Unfair Elections Act. I do believe, Mr. Speaker, that the effect, at minimum, of these changes in C-50 will result in voter suppression for citizens abroad in particular, and this is I'm not sure the Minister is fully aware of, could create actual chaos with respect to voting in Canada because of the new changes to a section that prohibits the Chief Electoral Officer from authorizing any use of ID that basically doesn't have an origin in Canada. And I'll explain why that could cause those problems. I'm going to stick with this phraseology that in the result, this is what's the problem, although I honestly think that in looking at what has been put in the bill, knowingly, I think the Minister has to realize what these impacts are going to be. And I hope that with some of the presentations during this debate and some of the criticisms he's already beginning to receive, he will be open to some serious amendments, including a couple that, to follow his own line, will be quite simple and could actually get rid of some of the serious blocking effects that I see. I would say that it's important also to note, although the Minister didn't really make hay of this in his own speech today, but in the presentation back in December when the bill was tabled, there very much was an effort to spin this bill in a way that I think created two false impressions. It's important to know. One, the press release and the backgrounder made it seem like the government was implementing the Frank judgment, which basically said that citizens away for more than 5 years now had the right to vote from abroad. And even that it was accepting it. It was very unclear from all the presentation whether or not the Frank judgment was being accepted. Well, it turns out, and it's important that everybody knows this, that C-50 does not repeal, does not remove any provision in the Canada Elections Act that was struck down by the Ontario Superior Court of Justice in the Frank decision. They're still sitting in the judgment. Reason for this is the government has clearly decided it's going to continue to fight to prevent citizens who've been away for more than 5 years from voting. They're appealing. They even sought a stay of the trial judgment in order to try to prevent it from going into effect. The Ontario Court of Appeal denied that stay. So the fact of the matter is the government is actively still seeking to keep disenfranchised those Canadians living abroad for more than 5 years. Yet the presentation of the bill made it look like this was somehow an effort to bring things in line. If this was really bringing things in line with the Frank judgment, all that would have had to have happened was to adopt the suggestion by the member for Halifax in her Bill 575 and simply repeal the same sections that the judge found to be unconstitutional in the case. And instead, Frank is being used as a supposed reason for a wholesale change of issues that never arose in the Frank case. So I think it's important to make sure that the Frank judgment does not carry this government along in any sense where people think that the government is actually respecting that judgment. They're still appealing it. Secondly, the press release directly claims that all of this Bill C-50 does is apply the same voter identification rules as were enacted by the so-called Fair Elections Act, C-23, and then extending those rules to Canadians voting from abroad. Now, there's some truth in that. There's some analogs that get brought forward. The vouching for address gets brought forward, etc. But what happens in C-50 is that a new prohibition on what kinds of documents the Chief Electoral Officer can designate as identity documents is inserted into C-50. It applies to documents used by all. Okay? And so this new section 143.2.11 applies to all electors, and it basically creates additional limitations on what the Chief Electoral Officer is free to authorize by way of identity documents. This does, because of the wording of that provision, have impacts in Canada, and it also makes it extraordinarily difficult for some Canadians abroad to actually produce the right kinds of ID that now they have to produce. They won't be able to because of this change. This is new. This was not in C-23. So I just want to set the scene by making clear that that's the case. It's also important to note, to set the scene, by noting that the Minister has downplayed it in his presentation here today, and I acknowledge that. There was a sign it wasn't going to go this way. The idea that there's a fraud problem from voters from abroad there's virtually no reality to this. The judge in the Superior Court of Justice, Mr. Justice Penny, basically said those kinds of claims are so unreal as to not even constitute pressing and substantial reason under Section 1 of the Charter to limit the right to vote. Riding shopping is not something that Elections Canada has ever seen as being a problem. All that happens at the moment is that multiple points of contact are available to increase the chances, the ease with which somebody from abroad can vote. The idea that there's something illicit going on when you choose to vote in where your parents live versus choosing to vote where you last lived seems to me to be a spin that's designed to make this look palatable or necessary when there's actually no problem. There is no such thing as riding shopping, except perhaps in the Minister's imagination. And it's important to clarify that when the Minister talks about 40,000 non-citizens being on the register, this was brought to his attention, and I'm glad that 2 years later he's acting on it. This was brought to his attention by the Chief Electoral Officer, and so the new mechanism that allows the Minister for Citizenship and Immigration to allow the Elections Canada access to the non-citizen database that the CIC has is great. But it's important to note we're talking about a fear that by error, that approximately that number of people are on the national register, not what's till this point in time the international register. Because to get on the international register, you have to actually show your citizenship. And so it's a separate issue dealt with in the bill, but it should not be confused with anything to do with a concern that non-citizens are voting from abroad. And I fear that unintentionally the Minister's emphasis on that could allow people to think that that's what's going on. No. The issue is cleaning up the national register for people who are here in Canada. And that's fine. That's a good thing in the bill, that one particular piece. I do feel duty-bound to note that the Elections Canada was not consulted on this except for the discussion a couple of years ago on this issue of trying to make sure non-citizens are removed from the National Register where they've, in error, appeared. And I think that's probably going to prove to be a problem at the time committee because we're probably going to hear some very detailed testimony from Elections Canada about many problems that this bill is going to create. And as long as the Minister is seriously open to changing them because these have not been foreseen, because there's been no consultation, we might well end up with a productive committee process. If the Minister thinks it's all been thought through and that whatever he hears from Elections Canada won't change his mind, then we will have a serious problem. And what we will have in effect is the Minister confirming that the intention here is to make it much, much more difficult to vote from abroad. And it's not just the unfortunate result of how the Act was written. Now let me go to this issue that's the sleeper issue. It's the question of Section 143, Section 143, sub 2.11. It's a new provision that basically creates a new prohibition on the Chief Electoral Officer. It says the Chief Electoral Officer is not permitted to authorize a type of identification that has been issued by an entity other than a Canadian government, whether federal, provincial, or local, or an agency of that government, and an entity that is incorporated or formed by or under an act of Parliament, or of the legislature of a province, or that is otherwise formed in Canada. It's a fairly complex wording. Bottom line is, as the Minister made clear, the issue is to make sure that ID only originates in Canada, essentially. That seems to be the general idea. The problem, however, is that it's been done in a way that might actually end up creating some serious administrative and even more serious problems here in Canada, because this new prohibition that's intended to deal with voters from abroad, so that they have to somehow produce Canadian or originated ID, is actually going to have an impact on everybody who shows up on election day here in Canada itself. And what's the reason for that? For that concern. First of all, formed in Canada is not a legally known concept, and it's not defined in the Act. And so the question of how, what formed in Canada, an entity formed in Canada, means is going to actually produce some serious problems at in terms of Elections Canada trying to scope it out, and then having that interpreted on E-Day by pressed elections officials. So we really need to make sure that this is going to be clear. Obviously, the intention probably is that organizations like the CNID are covered, and it's not just documents issued by corporations, say utilities bills, and etc. But the language is used in a way that is very, very unclear. Is, for example, however, here's an issue, a Visa card, that now you can use your Visa bill, your Amex bill, your MasterCard bill as one piece of ID to show address. You show up with it, and the deputy returning officer or the chief poll officer, whatever, looks at it and says, is Visa a company incorporated or formed in Canada? Is there a Visa Canada? Who gave you this document? The chances of that kind of minute questioning is going to be a problem. Even if it seems far-fetched, it actually is going to create serious workability problems. And I know for a fact Elections Canada is concerned about that extra burden and the mistakes that could be made. The second thing is, it's not at all clear to me that as I asked in my question to the Minister, that private leases will be caught by this wording, because the language is all about corporations or entities or government agencies. There's no scope there for a document that effectively has been issued by an individual, which is what private rental leases are, and they're often the form of identification to prove address that students in university towns use. So the bottom line is that this actually is going to create workability issues that I think the Minister had no intention to create, but that in committee we're going to hear about from Elections Canada. The unworkability issue is major. I am concerned as well that some party scrutineers who are now allowed to have to be asking to inspect identification documents as a result of C-23 will see these new rules as an opportunity to ask more often than they should for proof that this new provision is being met by whatever document has been presented by somebody showing up. Somebody shows up with a Visa bill. Somebody might say to the deputy returning officer, is that a document issued by an entity formed in Canada? No, maybe it's a document issued by an entity doing business in Canada. So you can imagine the opportunity for mischief that could occur. And here I'm being a bit like the Minister and sort of looking down the line at what kind of abuse is possible. The Minister looks in one source, one place, I look in another. We have to talk about that. Now, in my remaining minutes, Mr. Speaker, I want to talk about what everybody knows is the big concern. The big concern here is that the new requirements for citizens voting from abroad can be extremely onerous. They can produce delays that can result in ballots not arriving in time to be counted. The primary problem is the requirement that you have to register for each election, apply to receive your ballot, register. It's the same thing, kind of collapsed it into one, only once the writ has been dropped. You have to be aware it happens. You have to do it quickly enough in order to make sure that all the mail that has to occur between you, as the Minister has said, sending in your application, even if it's virtually, receiving back the special ballot and mailing it in, and doing that from Dar es Salaam or from New Delhi or from Sydney, arrives back in time. And there's all kinds of reasons to think that the way mail service works, the way that citizens abroad may not be immediately on top of when a writ has been dropped, could result in timelines that could be almost impossible to make. And I do believe we'll hear a testimony from Elections Canada to say that currently when people have not yet registered. They can register at any time at the moment in the International Register. But when they wait to register until the election has been called, there's an increased incidence of their ballot not arriving in time. So what we've done is we've created a system in this new bill where that problematic situation that we already know exists for some who wait too late to register to then get their ballot and then mail it in is now scripted in as the only way. So the delay issue is huge. We should also not underestimate the problem of ID. The longer you've been away, the chances that you've retained a Canadian-issued ID, apart from your passport, may go down dramatically. And that includes because in some jurisdictions, when you convert and get a local driver's license, you actually have to hand in your old driver's license. Now, if you're a hoarder and you actually keep every ID you've ever had, you may have no problem. But with no notice, the 2 million Canadians already abroad, so many of them may already have sort of jettisoned or lost the ID that they now have to use. And they cannot rely on the Chief Electoral Officer, Mr. Speaker, to issue a list of acceptable foreign ID that goes along with proving your address. So let's just say you still have to prove your address, your last known address, in the way the bill wants. But you can use your passport and some foreign piece of ID as a corroborating piece of ID. Chief Electoral Officer is not permitted to allow that, even though a foreign driver's license is at least as good in proving who you are as a Canadian license. It has nothing to do with address, but it does with identity. And so there are serious problems of actually producing two pieces of ID for some abroad that we have to take into account. Now, let me end by talking about vouching. The bill gets rid of the possibility that you can vote where you have a strong, some kind of a strong connection to a relative. And so it's focusing only on your last known address. The problem is you do have to prove this affirmatively. If you don't have a piece of documentation saved, like a driver's license that in New York State you've given up to the Americans, then you basically are going to have to rely on this new vouching provision. The new vouching provision says that somebody who currently still lives in the riding that you are saying was your last place of residence, you have to contact them and say, you remember me? I was your neighbor 7 years ago. Can you please do this attestation? I have to do a statutory declaration. I need to see your ID to prove that you're actually a voter, and I need you to fill out this form. It needs to get to me, and then it has to be part of my package in applying to be able to vote. Okay? Mr. Speaker, you can already obviously see the one big problem here is the delay that it's going to create. The need to use vouching within a 35-day election campaign period is already going to make it virtually impossible to make that deadline. But the other issue is all the same rules as came into C-23 apply. A person cannot vouch for more than one. So what if you're a family of 4 abroad and you can only find, if you're lucky, you can only find one neighbor still where you used to live, and that neighbor lives alone or is a couple, that person can only vouch for one of you. The other 3 are out of luck. So it's very, very clear that the issue of how the vouching system will work is not going to be anywhere near as easy as it is, or relatively easy as it is here in Canada, physically in Canada, when somebody on E-Day, on Election Day, actually goes down with the person and vouches for them. The idea of saying that the rules are the same for those voting in Canada and those voting abroad is a very formalistic understanding of equality, because when you apply the same rules to very different circumstances, you produce serious disadvantage in complying with the rules. Let me give you another example. And the thing is, in committee, we're going to find example after example like this, and the minister's really going to have to get his mind around them. Students abroad who, say, going off to do their master's or PhD, quite often they're heading off from a previous university existence. Now they're going to have to, sitting in London or Paris or New York, prove that their last residence was this university town, and pretty much the only people who know that that was the case were former students who themselves have moved on. How is it that we're going to actually create a proper vouching system for that particular case? It may sound like it's an imaginary issue. It's not. When you think about how students move around internationally, they usually move from a previous university town or a dress that was based on their previous education. So, Mr. Speaker, what I would say is that in the result, C-50 is a clear exercise in suppressing the votes of citizens abroad in a way that actually is diametrically opposite to the spirit of the frank judgment that started out being invoked by the minister as the reason for these changes. And I very much hope, again in sympathy with the minister's illness today in terms of the flu, it seems, I won't hit too hard anymore, but I very much hope that the minister is not doing this intentionally and that for once in committee we're going to get serious changes based on evidence that there are problems with this bill. Thank you.
Questions and comments? Question et commentaire. The honourable member for Bonavista, Gander, Grand Falls, Windsor.
Again, I'd like to thank you, Mr. Speaker, and congratulate my colleague again, who we've been through this a few occasions now, where we've talked about changes to the Canada Elections Act. Here we go once more, and yes, I mean, with the 99% of his speech is certainly something I agree with. One of the issues I want to address with him, though, and that is the issue of coming into force, which states that it comes into force 60 days after Royalist, 60 days. Now, on top of Elections Canada getting used to the changes made in the former bill, C-23, this is going to be a particularly hard thing to do, especially when you're dealing with outside entities, especially on the issue that he brought up about the Canadian entity issue. And how do you train, or how do you get the poll clerks trained to the point where they're able to recognize that? This could result in the mass confusion I think he's talked about. I'm not sure if he addressed that issue, but could he address the coming into effect of this particular piece of legislation?
The honourable member for Toronto-Danforth.
Mr. Speaker, that's an extremely good question. In fact, I have taken the liberty to talk to Elections Canada about the specific issue, and I very much expect that their testimony will be that 60 days will be impossible. And the transitional provisions of the Act do say that it goes into force 60 days after entering into force. Goes into effect 60 days after entering into force. Yes, it's not just poll clerks across the country having to be trained, but it's also the central staff at Elections Canada in Ottawa that will be receiving the applications from citizens abroad. Now, they're in a better, more concentrated position to pass judgment on the identity documents that are coming in, but even they are going to need to do this accurately and take the time to do it within very limited period. So I actually believe personally, and I believe I've had it confirmed in a discussion with Elections Canada, that the 60 days is completely unworkable.
Question et commentaire. Questions and
comments?
Deputy.
The honourable member for Pointe de l'Île. Thank you very much, Mr. Speaker. If I summarize this in simpler terms, once this bill is passed, I will have to call my friends. I have many of them who live abroad to study or because they got contracts from a Canadian company working abroad. If they want to vote in the next election, they should start to prepare now. Otherwise, unfortunately, they won't be allowed to vote. I think this will cause a great deal of stress for people who are in a country where they may not speak the language, where they don't know many people because they haven't been there very long. I think it's totally ridiculous of the Government of Canada to treat its citizens that way, whether they live on Canadian soil or not. My colleague mentioned students abroad who are quite stressed to begin with and who are going to have to start thinking now about preparing all these documents. They don't have a driver's license, they don't have a Canadian Medicare card because they no longer live here. So what do they have left, Mr. Speaker? Thank you very much.
Toronto-Danforth.
Oui, Monsieur le Président, ça serait...
Yes, Mr. Speaker. That would be good advice to warn people living abroad, such as students, as described by my colleague, that they have to be prepared. The problem is you can't apply to register until the elections are called. So you can be ready and have a few identity documents, but you can't actually apply until you know that elections are going to be held on a given date. Moreover, it's not clear that you can contact someone in advance to have them swear that, yes, you were in this or that riding when I lived there and I will sign this. It's not clear at all in the legislation that this can be done in advance. It's possible that one has to wait until the election's called. So there are real obstacles here. And personally, I know that this has to be clearer. I don't know why these obstacles exist. In the United States, a person can register. One has to do it every year, but you can do it on January 1st of each year. But here, now, you have to wait until an election is called. That makes no sense.
Questions and comments? Question et commentaire. The honourable member for St. John's East.
Thank you, Mr. Speaker. And I listened with care to my colleague's exposition of the law, and it bothers me tremendously to know that even though we have a fixed election date, and the law now says the election will be October 19th, that there's no opportunity. I mean, even if you wanted to ensure that each election you had a fresh voters list for Canadians living abroad, that surely the doors could be open now. How many people would have to, estimated, register and be processed and do all of those things within the 35 days of a writ? And what possible reason could there be for not starting that process January the 1st of an election year under the fixed election law?
The honourable member for Toronto-Danforth.
In terms of numbers, we know from the court case and from some other testimony, the government alone believes that 1.5 million Canadians would be potentially enfranchised by getting rid of the 5-year rule. In terms of those with the right to vote, the right age, therefore the right to vote, who would be added to this beyond the military, diplomats, etc., who are excluded from the provisions of all this. Let's say from the court in the Frank case said it's at least 1 million. Now, that doesn't mean that 1 million people want to vote or will try to register. But the fact of the matter is it's a right to vote, and if you have that degree of connection to Canada that you want to vote, then a certain percentage of that 1 million people will be what we're dealing with. And the idea of shoving all of this into the campaign period and overburdening Elections Canada makes no sense. Contrast that to France, which is going out of its way in the recent years to make it easier and easier for citizens abroad to vote. You can do it postally, you can vote by internet now, and you can also go to one of over 700 locations around the world to physically vote. They do 3 different ways to make it as easy as possible. So as they're trying to make it as easy as possible, this in the name of some kind of weird set of principles that have no application to any known mischief or problem, this government is going in the opposite direction.
Questions and comments? Question et commentaire. Honourable Deputy de Sherbrooke.
The honourable member for Sherbrooke. I think you're in your place. Yes, I am, Mr. Speaker, and I thank my colleague for his speech on Bill C-50. I wanted to ask him a brief question about the Frank decision at Ontario Superior Court. Does he believe, as the government claims, that that's a real response to the Ontario Superior Court decision, which specifically mentions Section 11D of the Elections Act? So does he really think that's an appropriate response to that Ontario decision that's contained in C-50? Or is this just a way for the government to try to change the law while claiming it's a response to the Ontario Superior Court decision. The honourable member for Toronto-Danforth, you have 1 minute to respond. Yes. Well, it's ironic, but yes, it is a response, but it's not a response in the sense of obeying the decision. It solves things in anticipation of the fact that this will be confirmed by higher courts like the Ontario Court of Appeal and maybe the Supreme Court of Canada. The decision is well argued, well reasoned. In my opinion, there's no better than a 5% chance that the government will win on appeal. So yes, it's a response to the fact that now one will have the right to vote when one has been outside of Canada for 5 or more years. The government of Canada doesn't want it to be too easy.